SJC-12167, Commonwealth versus Bin.
Mr. Reardon, good morning.
Good morning, Your Honors. Theodore Reardon on behalf of the defendant, Peter Bin. The first issue presented is the jury's question about rendering factually inconsistent verdicts. The jury asked, if we find the defendant guilty of one or more of the underlying felonies, can we still find him not guilty of felony murder? And the answer to that question under this court's decisions in Resende, Blackwell, and Scott is clearly yes. And under this court's decision in Wood, the jury has the inherent power to render inconsistent verdicts. As such, the jury should have been told, yes, they can render inconsistent verdicts.
Well, actually, the question, the answer can be yes without being inconsistent. There is that extra element that says the death did not arise as a result of the underlying felony.
I'm sorry.
There still is the element in felony murder that the death arose as a result of the felony.
Yes, but I don't think the jury was asking that question.
Probably not, but it's a more complicated answer than simply yes, you may render an inconsistent verdict, because the elements of felony murder are you commit the underlying felony and the death arose during the course of the felony. That's not the precise words, but there is that additional element. So why must the judge have understood it to be simply to ask you about the verdicts being inconsistent?
Well, because the jury wasn't questioning about the additional elements. They were asking, is it possible to find him guilty on this and not guilty on that? That was the question.
Was there anything that the judge said? I know your position is she didn't answer their question.
Yes.
Or didn't. But is there anything she said in response to that question that was legally wrong?
Yes, I think so.
What's that?
Well, first
she
of all,
re-instructed, right?
First of all, she re-instructed on intent relative to joint venture, which is non-responsive. The second thing
No, other than what you say is non-responsive,
yes.
Is there any of the words she used to instruct them, were they legally wrong?
Yes, and the answer is this. The judge instructed that if the Commonwealth proved the defendant knowingly participated and he shared an intent to commit the felonies and a death occurred, then the Commonwealth has proven felony murder. And I would suggest to you that's tantamount to saying no, to answer that question. They're basically saying no, if the Commonwealth has proven these things, then you must convict of felony murder.
But if someone knowingly participated with shared intent, aren't they a joint venturer?
I'm not disputing that that's an accurate statement of the law, but as to the answering...
Yes, that was my question. Is it what she said was an accurate statement of the law?
It is an accurate statement of the law, but in response to their question, it's an answer no.
Okay, well, let's move on.
So, Mr. Reardon, obviously the jury can have inconsistent verdicts. The jury can engage in nullification. The judge doesn't say, now, if they come back with a question, can we find the defendant not guilty if we think he's guilty beyond a reasonable doubt? Just because they can have inconsistent verdicts doesn't mean that the judge has to instruct them. You may have inconsistent verdicts. They don't have a right to jury nullification. They don't have a right to be told they can have inconsistent verdicts. It's just that the verdict may be inconsistent.
Well, again, under the court's decision in Woods, the jury does have an inherent power to do that.
And they do have an inherent power
Yes.
of jury nullification as well.
Yeah, and are you arguing that it's a defendant's right for that instruction more than a juror's right to that?
No, yes, I am arguing that, Your Honor. The Commonwealth has cited to the Diaz case for the proposition that a defendant does not have a right to this as a jury question, as a jury instruction. But this wasn't a request by the defendant for a jury instruction. This was a question by the jury, and I would suggest to you that the jury is entitled to an accurate answer of the law.
So if there was a child rape case, so suppose there was a rape case where Commonwealth charged a 17-year-old boyfriend, girlfriend, one of those horrible situations where there's a 17-year-old and a 16-year-old in the police charged the boyfriend. If the jury came back and said, can we ignore the law and find him not guilty of child rape because we don't think this is appropriate? And the answer to that is yes, you can't ignore the law, you can nullify the law. Would you have the same position as you do now?
I don't think the jury was asking about nullification. They were saying, is it possible to reach inconsistent verdicts? And I don't think that equates to nullification. I think they're different things. So, but if they come back and ask...
So what's your position, though? If the jury asks, can we nullify the law, what would you say to that?
Unlike the law on inconsistent verdicts, there is no case law, to my understanding, that says that the jury has inherent power to do nullification. I don't believe there's case law that says that.
So what are you saying that the judge should have said?
The judge should have said, could have said as simply as yes, but if he wanted to elaborate, could say, you have the power, you should consider each indictment separately, and you are free to decide each indictment, consider them separately, and decide them separately. And that is clearly the case law. So our decision on one indictment does not dictate a decision on another.
So that's not answering the question precisely. It's a good answer to look at each indictment separately, have to prove each one beyond a reasonable doubt, but that wasn't, that wouldn't be responsive precisely to the question either.
Well, like I said, an answer yes would be appropriate, but the judge could expound that she had already instructed initially in the original instructions to consider each indictment separately, but repeating that would, I think, would be responsive to the jury's question.
Well, then she already said it once.
Well, she did, but, well, in the original instructions, but they came back with a question.
If I can turn you to the Red Sox hat.
Yes.
There was a major contributor who was Mr. Bin,
Yes.
and there was a minor contributor who was unknown.
Correct.
Unknown because there were not enough, forget the name, alleles to identify somebody, or unknown because there were enough alleles, but it didn't match anybody in the database.
I believe other people involved here were excluded, if that's your question. But I believe there was insufficient alleles, and that's why it was not a major.
So it's not as if we would be able to identify somebody if they were in our database, but they're not, but we simply don't have enough alleles to identify anybody, even if they were in the database.
Well, yes, but again, the other people were excluded.
Right.
Yeah.
So was there any evidence as to how recently, as to what it means to be the major contributor in terms of how recently Mr. Bin was wearing that hat?
I'm sorry?
Was there any, he was a major contributor. Was there any, I mean, the concern is that, yes, we can fairly infer that he wore that hat and that his DNA wore off on the hat. The only issue is do we know when he wore the hat?
Yes.
Was there any evidence as to the timing, as to whether or not that type of DNA would need to be fresh in order to be a major contributor?
No, there was not. No.
So we basically, I mean, the case, as I gather it, is you've got the DNA in the hat, and you've got the telephone evidence, and you've got the CSLI evidence.
Yes.
Is basically what the case rests on, as well
Yes.
as the gang affiliations, which is weaker with Bin than it is with the others. That's where the case rests.
Yes. Yes. So, and going on to the, in talking about the second issue, Your Honor, which is the admission of the T-Mobile records, which were not self-explanatory. This court recently came out with the Dabney decision, which upheld the exclusion of non-self-explanatory business records. And the court held in that case that where such records are not self-explanatory, there should be someone come in to explain them. The Commonwealth in this case contends that Trooper Cardus was so qualified. He does have training in cell phone technology and other aspects of cell phone technology, but as to T-Mobile's proprietary records and how they create their records, There was no evidence that he had any kind of training on that. He said he became familiar with them. And he didn't stop there. He went beyond that to talk about how T-Mobile builds its cell phone towers and about how they stack the antennas and about how the particular antenna relates to the coding on the billing. Well, where did he get that training? I mean, he would have to get it from T-Mobile. It's not something you can just figure out on your own. But there was no evidence he had any kind of training like that. The Commonwealth says, well, he's done this kind of deciphering of T-Mobile's records many times in the past. Well, you know, repetition doesn't equal accuracy. He could be doing it wrong every time. In light of the lack of evidence of his ability to decipher, training and experience to decipher these T-Mobile records, they should not have been admitted.
Now, am I correct that there was no objection to their admission?
There was not.
And there was no objection to his qualifications to testify?
Correct.
So we're in substantial likelihood territory.
Yes. Yes, and there is a substantial likelihood in this case, Your Honor, because the only evidence that places him at the scene at the time of the crime is the CSLI, if it does place that, because it just places him in the general vicinity. But that is the only evidence. Without that evidence, you're left with a DNA hat. But under the Gonzalez case, in that case it concerned the defendant's motor vehicle being present at the scene, and the court said, well, just because his motor vehicle was present at the scene, or her motor vehicle was present at the scene, doesn't mean that she was present at the scene. And so likewise, you fall into the same situation where you have the defendant's hat that contains his DNA found at the scene, but it doesn't mean that he was there at the scene. So the CSLI evidence is key to the Commonwealth's case.
But I gather we have no expert testimony anywhere that said that Trooper Cardews misinterpreted the CSLI records.
No, we don't. We don't, but that doesn't mean that they're accurate, his testimony.
No, but I mean, if we're going to be falling into substantial likelihood of a miscarriage of justice, wouldn't we need some evidence to say that this trooper, who you claim was unqualified to do it, interpreted it in a way that a true expert would not have done?
I think we can rely upon his own testimony that he didn't claim to have any kind of instruction from T-Mobile or anyone else about how to read their records. The third issue, Your Honor, would be the motion for a required finding of not guilty. The Commonwealth presents a lot of evidence about gangs in the record. But if you really discern it, most of it concerns other people, not the defendant. In particular, the three key things I think that they have are the photo of the defendant at what appears to be a nightclub. It's undated. It doesn't establish that the defendant was a gang member on this time in 2012. And in addition, it shows 4 individuals, 2 who are wearing red, 2 who are not, and they're holding up their hands, but you have it in the appendix on page 154. It's not real clear what they're doing with their hands. I don't think that establishes that the defendant was a member of a gang on the night of this incident in 2012. The second thing they have is testimony from a police officer that 2 years before this incident, in 2010, the defendant was in an accident and was found in the presence of gang members, the defendant was wearing red. I don't think, again, that establishes that he was a gang member at the time, or certainly not in 2012. And then the third thing they talk about is that the defendant was present, again, 2 years early in 2010, when there was a gathering of people, including some gang members. There was no evidence that everyone there was a gang member. And the officer who witnessed this testified that he saw some people wearing red shirts and Red Sox hats. But he never testified that the defendant was wearing those clothes. He never testified that the defendant was anything other than present at this meeting. And so those are the three things that they claim establish that the defendant was a gang member at the time of this incident, and none of it does. They also mentioned that the defendant had a nickname. Well, I'd suggest to you that nearly every defendant who comes before this court has a nickname. That's not that unusual, and there's no evidence at all that that was in any way affiliated with a gang, given to him by a gang, as the Commonwealth claims, or in any way that it was somehow gang-affiliated in some way. So I would suggest to you the evidence of gang is non-existent, and a required finding should have been given on that basis. Also, the defendant contends that a required finding should have been given on the issue of whether the defendant, assuming he's placed there at the scene, that there's insufficient evidence that the defendant knew that other people were armed. There's no evidence that the defendant was armed. There's no evidence that the defendant was inside at the time, and the Commonwealth did not claim at trial that the defendant was inside, other than the vaguest of allegations of saying it's not inconceivable he was inside. That's the best they could say. So at best, if the defendant is placed there contemporaneous with this incident, at best it places him outside with no knowledge of what was going on with arms inside, and thus he cannot be convicted of any kind of armed offense.
Now, the jury, I gather, was instructed about unarmed robbery?
Yes.
And refresh my memory as to what the maximum penalty is for unarmed robbery.
I don't know, but it qualified for the felony murder.
First degree or second
Yes.
degree?
Yes.
Unarmed robbery is a life felony.
Is a life felony. So how is it going to help you if he was unarmed, it's still a life felony?
I'm sorry?
If the judge instructed on unarmed and you are, and let's assume for the moment that you are correct, that the evidence is inadequate, that he was armed or knew others were armed, wouldn't that simply drop it to unarmed robbery, which would still be a life felony, which would still make it first-degree murder?
Well, the jury came back with not guilty on that predicate of unarmed robbery. They came back not guilty. They did not find that as a predicate.
What'd they find to be the predicate here? Armed robbery?
Yes, they found it on armed robbery and armed home invasion and attempted armed robbery. Yes.
Okay, but if they found him guilty of armed robbery and the evidence was inadequate as to the armed part, wouldn't we say that the jury found him, wouldn't we then drop it simply to unarmed robbery?
Well, it would, but the jury found him, did not find that predicate.
Okay, anything else?
No, that's it. Thank you, Your Honor.
All right, thank you. Mr. Charles. Good morning.
Good morning, Mr. Chief Justice, Associate Justices. Jamie Michael Charles, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. With me today is former Assistant District Attorney David Mark Solid. He was one of the trial ADAs for this trial. I'll start where my brother started and address the issue of the jury's question. While we argue in our brief, and I will argue to you today, that it is inappropriate for a judge to instruct a jury that they can return factually inconsistent verdicts, I don't even think we necessarily need to get there to resolve this claim, because in reviewing the judge's answer, which, as Justice Gaziano fleshed out, was a legally correct response, we look to see whether there was an abuse of discretion in the way the judge responded to the question. And I don't think the defendant can establish that, based on the general nature of the question that the jury asked, that the way the trial judge Justice Tuttman chose to respond to that question was wrong. And there's, I think, two reasons for that. First, as I'm sure many of you are aware, as you previously were trial judges before you were elevated to this court, it is often the case that a trial judge, in responding to a jury question, is going to simply re-instruct on what they view to be the relevant portions of the law that they previously instructed on. Judges are loath to deviate from their original instructions and touch on the facts or provide instructions that could in any way be viewed as contrary to the instructions they had just provided. I would also just note that if you review the transcript immediately before and after the reading of the jury question, even trial counsel for the defense initially interpreted the question as a legal question about the elements of felony murder. This novel interpretation about, it actually relates to separate and individual indictments and, by extension, factually inconsistent verdicts, is raised by Attorney Busso after the parties discuss this and the judge resolves to instruct the jury as she ultimately did. So even counsel for the defendant did not initially interpret the question in the way my brother is now suggesting it had to be interpreted. So I don't think the judge abused her discretion in the way she responded to the question. But even if we get past that point, I think, admittedly, it's an appeals court decision, but the Diaz case pretty clearly states, citing numerous federal jurisdictions, we don't instruct jurors that they can return factually inconsistent verdicts. We permit them to stand if they are returned, and essentially, as I think Justice, Quirico noted in his concurrence in the Dickerson case, that's because the Commonwealth is without remedy to challenge a not guilty verdict. But we certainly wouldn't affirmatively instruct them to return factually inconsistent verdicts. That would be at odds with the preceding instruction that every trial judge gives, that the jury is to follow the law and return a verdict that is consistent with the law as they give it. And
Isn't it analogous to the jury nullification situation? That you wouldn't instruct on that either?
I mean, I think that is an additional point. Yes, I think it is. I disagree with my brother that there's much difference between the two. And so I think that that's also correct. And finally, I'll even note, as the Chief Justice noted right up front, a yes or no answer would not have been a clean answer to the question, because there is a scenario whereby they could have found Mr. Bin guilty of, it was armed home invasion and attempted armed robbery, just to be clear for the record. They could have found him guilty of those predicate felonies, but concluded that the death did not occur during the commission of those felonies, and therefore found him not guilty of felony murder. So a straight yes or no answer would not have been responsive to the question asked, even if you want to interpret it in the way the defendant interprets it. Turning to the second issue with regards to Trooper Carduce, this was noted in the questioning of my brother, but I think it's important that, again, the Commonwealth feels that Trooper Carduce was qualified, and I'm happy to talk to that, but I think we have to view this through the lens of what happened at trial. There was absolutely no objection to the qualifications of Trooper Carduce. No, there were 2 defendants and 3 separate defense attorneys. None of them requested a voir dire of his qualifications. None of them contested the authenticity of these records or challenged their admission, other than their ongoing objection to the procurement of those records through the administrative subpoena statute, which is not at issue before us today. So there was no basis for the Commonwealth to probe Trooper Carduce any further than it did about his knowledge and experience, although I think they did adequately flesh that out. He established that he was a member of the Technical Surveillance Unit of the Mass State Police for 5 years, that he was a member of the FBI's Cellular Analysis Team for 3 years, that he had reviewed these exact kinds of records, and I believe it was over 30 cases at that point, and testified to his analysis of those records in numerous courts and in grand jury, that he had reviewed specifically T-Mobile records on numerous occasions, and he provided context for the jury in trying to interpret these. He was candid that different companies use different terms, whether it be repoll or NEID or LAC, which is location area code. He, in fact, provided a fairly similar analogy, saying if you look at the LAC, that is akin to a zip code, and then if you look at the specific tower number, that is akin to your physical address. So he tried to make it more understandable to the jury. He clearly had an understanding of what these respective things meant. And the defendant, again, I think as the Chief Justice alluded to, hasn't demonstrated, because we're clearly in a substantial likelihood of a miscarriage of justice sphere here, even if you find there was error, he hasn't shown that what Trooper Carduce testified to was inaccurate in any way, shape, or form. He was very candid that this testimony did not put the cell phone in the defendant's hand, and it certainly did not pinpoint the exact location of the defendant. He merely said that the defendant would be, this put the phone associated with the number in a general vicinity of that tower, which would vary depending on how far away the next tower was, and occasionally he could ascribe a particular segment of a tower, although he was also candid when he couldn't. And in those situations, he said, all I can tell you is that within some 360-degree area of that tower, maybe it's a mile, maybe it's 3 miles, that cell phone with that number was hitting off that tower at this time. That was the extent of his testimony. So it wasn't the linchpin that my brother suggested it was. It was one piece of evidence considered in totality with a variety of other evidence.
Can you refresh my memory as to how we know that that was Mr. Bin's cell phone?
Yes, the testimony came in through Deputy Chief Roy Frost of the Billerica Police Department that the call detail records and subscriber information for that phone were introduced into evidence. I believe it was Trial Exhibit 76, and that subscriber information established that this number was attributed to Peter Bin.
So he had, it's actually in his name. We almost never get a cell phone that's actually in the name of the
And it
of
wasn't the
defendant.
case for all the defendants. For defendant Touch, the phone was in the name of his girlfriend, Christina Dawn, but she was put on the stand to establish. So, and again, with Adam Bradley's cell phone, it was in the name of JMB Construction, but this phone was subscribed to by Peter Bin. And so while we certainly couldn't establish that he held the phone through the CSLI testimony, it did show that a phone with a number that is subscribed to him, was in the vicinity, was making calls to the other 4 of the 5 defendants that had cell phones on their person, Arias, Bradley, Touch, and Keogh, and a hat with his DNA profile as the major profile was found on the precipice of the back door to the kitchen through which the assailants entered the residence. And there was testimony that that hat was not there in the immediately preceding the home invasion. And as to whether or not, just sort of bleeding into the third issue, whether or not the defendant was in the house, the testimony was clear from Ryan Kohler, the brother of the deceased, that when he entered the kitchen, he saw 3 armed assailants pointing guns by the door through which they had entered. He then observed a 4th defendant who was subsequently identified as Jason Estabrook behind the fridge on the opposite side of the kitchen. So there were 4 assailants in the house, 3 of whom clearly were, the testimony clearly established, were armed. The remaining 2 co-defendants, Stephen Touch and Sofan Keogh, were the 2 individuals who were either the registered owner or typical user of the 2 vehicles that were observed traveling to and from the scene. So I think it's a perfectly fair inference based on circumstantial evidence that Stephen Touch and Sofan Keogh were the drivers who were operating their respective motor vehicles, and that the remaining 4 parties to the armed home invasion, Mr. Bin, Mr. Arias, Mr. Bradley, and Mr. Estabrook, were the 4 individuals who entered the house. Mr. Estabrook was the 4th individual who was not observed with a firearm. Therefore, Mr. Bin was clearly one of the other 3 individuals in the house armed with a gun. And even if you don't want to draw the inference that he was one of the individuals holding a gun and pointing it at the Kohler brothers, I think it's still a fair inference to assume that at a minimum 3 of the 6 members who participate in an armed home invasion are in possession of firearms. It's not unreasonable to think that the other 3 members, if it was 1, I suppose you could argue that maybe he brought it along and no one knew. But I think 50% of the participants possessing and brandishing weapons, mind you, before there was any actual shooting, because there was the physical scuffle between Estabrook and Quinton Kohler before a gunshot was fired. So either they all knew going in that everyone had a firearm, or at the very least anyone who was in the house upon entering knew that the others had a firearm, and that was before the physical scuffle and before the gunshot. So I don't think there's any credible argument to be made that the defendant did not know what they were there for and did not know that people had guns. And I think the gang evidence, which was admitted for a very limited purpose, essentially, to help establish this joint venture and to establish this familial close relationship, to show that, if an individual here, Adam Bradley, is going to go do something very serious and engage in an enterprise in which life and limb are at risk, he is not going to pick some random people off the street who he can't trust. He is going to find individuals whom he has a solid relationship, who he knows he can count on. And that was the scope of the evidence. There were a lot of objections and a lot of limitations put on by Justice Tuttman. She kept this evidence narrow. Detective Withrow essentially testified to the characteristics of gang membership, to the colors worn by Bloods, to the signs they use, to the fact that they all are assigned nicknames. And he testified that this defendant either exhibited some of those indicia or was commonly found in circumstances associating with these other admitted members like Bradley and Touch. So I mean, I guess viewed in isolation, each individual instance may not be the most compelling evidence that this individual associated with his co-defendants and would have known what was going on that night. But I think viewed in totality, certainly in the light most favorable to the Commonwealth, it sufficed, if it was even necessary at all, given the other evidence the Commonwealth had. Lastly, I'll just note, I certainly don't think this is a situation where reduction of the verdict under 33E review would be mandated. Obviously, the law in a post-Brown world is different, but this case occurred prior to Brown. And I would also note that this defendant is a far cry from the defendant in Brown in any case, because, as I've argued, I think the evidence here clearly places this defendant in the house with a firearm, even if he wasn't the individual that ultimately fired the fatal shots. So if there are no further questions, the Commonwealth will rest on its brief and ask that you affirm the defendant's convictions.
All right, thank you.
Thank you, Your Honors.